Hello, my name is Sandra Coliver, and I'm the Senior Legal Officer for Freedom of Information and Expression with the Open Society Justice Initiative. Today I'm going to talk about the right of access to information, its history, its basis in international law, some of the main elements of the right, and some of the main controversies. Starting with the history. It has a long history, but the right really only matured in the 21st century. The first country with the right to information law was Sweden in 1766. Then in 1951, Finland passed a law, the United States in 1966. And by 1989, there were 13 countries only that had a right to information law. Then the Berlin Wall came down and the countries of Central and Eastern Europe embraced democracy, and chief among the rights that they entrenched was the right of access to information. In the 27 years since 1989, 94 countries have adopted laws. There's now a total of 107 countries that have access to information laws on their books. These include the population giants of Brazil and China, Indonesia and India, the US, Russia, and most recently, Nigeria. In total, nearly 6 billion of the world's 7.1 billion people now live in countries that have a right of access to information on the books. In international law, the right emerges from the right to freedom of expression, and in particular, the freedom to receive, seek, and impart information and ideas of all kinds. Initially, this was interpreted to grant a freedom for people to exchange information between those who wanted to exchange information, a freedom to seek and to receive information free from government interference. It was only in this century that international bodies and courts started to interpret the right very clearly to grant a positive right to get information from public authorities. So first, the American Court on Human Rights issued a judgment in 2006, and then in 2011, the UN Human Rights Committee issued a general comment that affirms that positive right. And the general comment affirms 10 components of the right, which have now achieved widespread consensus. Those include, first, the right is a right of everyone, not just of citizens. It is a right that applies to all public bodies, legislature, executive, judiciary, and also to private entities that perform public functions. Third, there is a presumption in favor of disclosure. 4, exceptions must be limited. They can only be necessary to protect legitimate interests in a democratic society, and they must be set forth in law. Fifth, even if disclosure would harm a legitimate interest, governments should make information available if the public interest value in the information exceeds the likely harm to the protected interest. 6, states should proactively make information available. 7, states should establish procedures to make the right accessible and affordable. 8, fees should be minimal. 9, authorities should state reasons for any refusal to give information. And 10, people have a right to appeal any refusals to disclose information to a court or independent authority. Now, there are 3 significant open issues that are still in controversy. The first one is one of the most fundamental. Who holds this right? The UN has asserted that everyone holds this right. A number of national laws restrict the right only to citizens or possibly to residents. The European Court of Human Rights has been even narrower to say that the right is held only by journalists, NGOs, academics, and others who analyze and compile information and contribute to public debate. a fairly narrow interpretation that was affirmed most recently in 2013. A second area of controversy concerns the bodies to which the right applies. Clearly to the executive, some countries will say that advisors to the president are protected, or that the intelligence agencies or the defense agencies are protected. A lot of the information that those agencies hold will be protected under legitimate exemptions, but that doesn't mean that the whole agency should be exempted. There's also a question about private entities that perform public functions. What are public functions? So, generally it's accepted that public functions include the provision of public services, water, power, energy. What about transportation, railroads and airports? What about hospitals? There's also a question about access to information from bodies that receive substantial public funds. So private universities that engage in research with public funds, or residential care facilities. A third area concerns the extent of exceptions. And there are two categories of exemptions: those that protect private interests, such as privacy and commercial secrets and trade secrets, and public interests. And the public interests are really an extensive list, and governments are very reluctant to release information, for instance, that could harm national security or public safety or law enforcement, or the free provision of advice within government or international relations. There are 9 areas of legitimate public interest that are set forth in my paper. There's also a question about the extent of harm that has to be shown that will likely occur to these interests before information should be withheld. A couple of cases to provide examples. In the area of privacy, public officials assert that they have privacy concerning their salaries and their expenses and their conflicts of interest. And courts around the world have been pretty clear that public officials have to disclose information about how they handle public funds. And so information about their expenses has to be public, their salary bands, their titles. There's also a question about contracts that private individuals make with public authorities. Recently, there was a decision that a contract, even that specifies fees paid to lawyers, had to be made public. There are questions from India. Human rights activists filed information to obtain a copy of documents recording the distribution of rations to poor people. They found that there was quite a bit of mishandling of these rations. And when the activists got access to information, the ration system was reformed. There's access to information about the environment. One of the most famous cases is from 2006. The Inter-American Court of Human Rights, in the case of Claude Reyes versus Chile, ruled that an environmental activist had a right to information about an American logging company that had just gotten a license to log millions of hectares in Chile. And the information showed that the company was abusive in the way that it handled natural resources. That established the right of access to information in Chile and throughout the Americas. A final area of recent controversy has been whether whistleblowers have a protected right to release information in the public interest. People such as Edward Snowden and Chelsea Manning. The European Court of Human Rights has affirmed that if the interest in the public information exceeds the harm to a national interest, and if the individual tried to use internal channels or internal channels would be ineffective, then that person does have a protected right to disclose that information, even publicly. In closing, it's clear that this growth and recognition of the right to information has had a significant impact in countries around the world in exposing corruption and wrongdoing, in promoting good governance and oversight, and in facilitating public participation in government. Perhaps the most significant transformation has been in the transformation of the culture of secrecies and bureaucratic aloofness to a new culture where individuals, including citizens, can ask questions of government, have a right to get answers, and have a right to hold their government officials accountable. Thank you very much for your attention.